Hey there, this is Heather Van Wild with Ring Works. Sorry, I wasn't sure the microphone was turned on. Anyway, um, yeah, tuning in about a couple of the news stories that we've been following over recent weeks that I wanted to kind of touch base with you about. So yeah, I'm gonna go ahead and start off. The first one that I mentioned, title of the video is Tiny Toese. Um, I'm not sure if I pronounced it, yeah, so there's been some buzz over Twitter this week because we found out on January 6th, which was a week ago today, he was arrested in Thurston. Um, and I'm still trying to get the whole story together, but at the very least, we have figured out information about charges there. They have stemmed from allegations of him being involved in attempted invasion of the governor's mansion in Washington state on January 6th of last year. So, 1 year to the day after the events that they're alleging, he got arrested. Now, I just got, this morning, I got the paperwork from Thurston County Court that was able to go in depth into this stuff. Now, this indictment, probable cause affidavit, filed February 16th, 2021. So there was a warrant sitting out for almost a year for his arrest, which that, when he got shot in December or somewhere around, I had interactions with somebody, a warrant check on him there. Um, but yeah, the charges they have against him was assault in the third degree against law enforcement, obstructing law enforcement officer, and criminal trespass in the second degree. Trying to Okay, here we go. Yeah, here's the more detailed information. Said he did intentionally. That they allege that he intentionally assaulted law. Um, they allege that he willfully hindered, delayed, or obstructed a law enforcement officer, and um, knowingly enter or remain unlawfully in the premises. Now, there's other of the documents that specifically go into count three, say that it was the governor's. That one. There were a lot of files that I was able to get from Thursday. Nope, not. This document here basically it confirms that he qualified for public defender. Wrong with that. Has pleaded not guilty. The release conditions reflected in the establishing. I know where that one is. That really. Here we go. So they are being surprisingly quick with the trial. The trial is actually for, I believe, of this year, so months away. Um, there is a omnibus hearing on the 19th. Basically, any matters that have come up between then. Um, in regards to bail, they did straight up. The court said that release on personal recognizance. Stop acting up. Let me try to see if we're out. Okay, is this working any better? I kind of have a feeling that the noise cancellation was an old setting that I probably don't need because this is a new mic. Yeah, noise filtering was exactly what I just turned off. Okay, okay. Sorry about that. This is one of those things I tried to set up as best I could, but this is literally I just got the rest of this gear in today, and this is the first time I'm getting a chance to try everything. Anyway, so yeah, the court has already acknowledged that they cannot reasonably assure that the defendant will appear, or there are concerns that he would seek to intimidate witnesses or unlawfully interfere with the administration of justice. Now, the information that I have is they only really looked at his Washington court records to come to that determination. I only saw a few vague mentions to anything in Oregon where he does have a conviction for assault 4 that he had to serve his time on and got released just before Christmas of 2020. So he does have apparently a cash bail set of $5,000, but based on everything that we've seen right now, even if he comes up with that, he is still being held on a separate warrant that does not have bail set. And what that appears to be is related to an arrest in Clark County about a week before his arrest in Thurston County. I'm hoping to know more in the next day or two once I get court records from Clark County. But, because it's not in Oregon, I'm having to go through the normal request process, pay for it, and they email it to me, and I'm still waiting to hear back. But it looks like they arrested him in Clark County on a sealed warrant from Oregon. And then, as part of that, they found the warrant in Thurston County from January 6th and sent him up there. Now, there is supposed to be a extradition hearing later this month in Clark County. So hopefully we'll have a little bit of a better idea by then what's going on, what the charges are stemming from here in Oregon, and things like that. Again, as I know more, I'll let you all know. But that is basically where we're sitting with in Thurston County with Tiny Toese. Best guess I have is this is related to stuff that happened in Park Rose neighborhood in Portland in August of 2021, where there was a large confrontation. It started off with right-wing protesters who had originally planned to set up a protest in downtown. They changed location at the last minute when they got word that there was going to be a counter-protest in the area. Some of the members of that counter-protest went to Park Rose, basically following the right-wing protesters, and there were escalations from there. I was not there. I have seen some pretty gruesome video and images from that. I'm not in a position to even try to get into the merits of what happened there. But yeah, so that's where we're at with this. The other thing that I wanted to go into, I'm just going to close these out and then reopen. The other story that I've been kind of sitting on because, up until recently I wasn't sure how to cover it tactfully because of concerns about the victim in the matter. So there was a case that I sat in October of 2020, where a stalking order was filed against Dixie Bailey, who was at the time a fan and supporter of Alan Swinney and a number of other right-wing groups. I haven't really followed what they've been doing since the stalking order because this was definitely life-changing. The stalking order, basically, there was a lot of testimony back and forth, but what the judge ended up deciding based on the evidence presented was that Dixie had found the home address of this person who owns a restaurant in the area and had made concerning statements that caused this person to have concerns, as well as supposedly coming back later in the night and other things that happened at other restaurants. And there was a lot of dispute on the actual events that happened. I don't really want to get into the specifics because, like I said, without being there, I can only go off of what the witnesses say and the filings. I will say that as I was sitting in the courtroom listening to the testimonies that were put forward by Dixie and her supporters did not match up with each other. It seemed witness prep was not very well done. And eventually the judge in the order, or the judge of the case, Judge Jones, did find against Dixie, saying that the stalking order would continue, which, as Larkin pointed out in the chat, did include a firearm restriction. They did pretty much immediately appeal that decision, and it went through the higher court here in Oregon. And a few months ago, they affirmed the decision of the county court here, but didn't issue an opinion on it. They just said, yeah, we agree with what the judge did. He did it right. And that's after they reviewed all the same evidence, all of the court transcripts and everything. So they saw the same thing everyone else did and came to the same decision. What came up interesting after that, though, was beginning of December last year, Dixie filed a motion to terminate. And this is where things start to get a little interesting. So the claim that was made was that on or about January 31st, 2021, which would have been a few months after the original stalking order was upheld, Dixie got a social media message from someone who knew Jolene, who was the person who filed the stalking order, saying that they had made a lie in order to obtain the stalking order. And the idea was that because this was a lie, the entire basis of the stalking order was founded on false pretenses and should never have happened. There are definitely some issues that come up from it. including I have spoken to multiple people who with knowledge about the situation, and they have basically said that the person who made this claim was somebody who used to work for Jolene at her restaurant and got fired under allegations of possible criminal wrongdoing, which I think if a testimony had been done in a cross-examination, the reliability of the witness probably would have fallen apart in an instant, because the timing and everything makes it seem like, oh, I just got fired, I'm going to make my old boss's life difficult. So, yeah, there was this filed. The actual filing was December 6th, I believe, of 2020. Oh, sorry, December 9th, 2021. So almost a full year after this alleged social media message, after the whole appeal process has run through the court system, then all of a sudden this claim shows up. Judge Watkins was the one who was set for this hearing, and she did not really like what was being claimed here and the process and everything. I went ahead and you know, after I got the court audio and I listened to it, there is no way I couldn't just share it with the broader world like this. So, you know, it's only about 10 minutes, but that's all it takes for a pretty significant teardown of Dixie and or her attorney, Chad Wolf. I mean, not Chad Wolf, Eric Wolf. I keep getting them mixed up because, you know, Chad Wolf was the deputy or the acting head of DHS during the downtown protests last year, or year and a half ago. So anyway, and for those of you who don't know, FTR is software that a lot of court systems use to record the courtroom audio during hearings and such. So they have a special player that they use to, you know, I can manage individual microphones and such. And I am realizing something got messed up in the audio really quick. I need to try to figure out what happened. Let's try this again.
Thanks.
There we go.
Okay, so we are on the record in 20 SK 02242. Who do we have? If I can have the lawyers, please introduce yourself, your bar number, and who you represent.
Morning, Your Honor. Cameron Green, 182982, on behalf of petitioner Jolene Malone, who appears via WebEx.
Okay.
Morning, Your Honor. Eric Wolf, 196570, for respondent Dixie Bailey, who is to my left.
Okay, and I saw that there were 2 additional lawyers listed. I don't know their participation. If I could have you all introduce yourselves and your role or who you represent, that'd be great.
Window popped up in the middle of your screen.
Can't hear you.
Had to unmute there. Good morning, Your Honor. Jane Moisen for petitioner 181864.
Okay, welcome.
Thank you.
Hello?
Hello, we can hear you.
Yes, I'm Thomas Nelson, 783150, attorney for petitioner.
Okay, well, welcome. Okay, so I've looked at the history of this case, and oddly enough, I'm wondering how it even came before me. It looks like there was a motion filed in December, a motion that should not have been accepted. Not sure why it was accepted, because it's a motion that we use for a hearing to contest the stalking order, and that has already occurred. That hearing occurred back 10/21 through 10/23 of 20, according to the records. And not only did that hearing occur, there's an extremely detailed opinion authored by my colleague dated November 19th of 2020 by Judge Jones that upheld the stalking order, and then the case was appealed to the Court of Appeals, and it was affirmed October 5th of 2021. So I'm not even sure why it's here. I don't know that there's even a legal basis for it to be before me this morning. Counsel, do you have a legal basis?
Your Honor, I think the legal basis was that case Edwards v. Baylor that stated, people can terminate stalking orders. They can't be for life. And since the trial and the appeal, we've got new evidence, which we wish to present, 2 witnesses who will testify that the underlying allegation to this stalking order, the main underlying allegation was that my client brandished a gun to petitioner. We have 2 witnesses who will testify that that was actually a lie, and that petitioner admitted to them that that was fabricated to meet the statutory requirements of attaining an SPO against my client.
Okay, I'll have you speak to it, but I'm not sure, counsel, that gets you there. This case cites the statute 163738. That statute is the statute that's intended to give someone the ability to contest a stalking order, an initial contest. That has already occurred. This statute is not 2 years later to say, hey, I just want to file a motion to get rid of the stalking order. If that were the case, everyone who had a stalking order against them would be filing to just terminate a stalking order.
I believe the case that opposing counsel is trying to seek reference to is CLC v. Bowman, which does give authority to terminate under ORS 30.866. However, as Your Honor noted, the motion to bring this matter about is facially deficient and should not have even been accepted. Shouldn't even be here today.
Yeah, I'm not sure why we're here. I mean, I understand that you have 2 people that are allegedly willing to say that she lied as the basis, but this should never have been accepted. This ex parte motion, it's not based on proper authority or points. And as I already stated on the record, that statute, she has had a contested hearing. It was October of 20, and it was upheld. The basis for the ruling was in a detailed later, dated November 19th of 20, and it was affirmed by the Court of Appeals October 5th. She's essentially just trying to relitigate.
Your Honor, with all due respect, we're not trying to relitigate the whole thing.
You exactly.
We
you
come
are.
in because of we come in because of this new evidence. So are we just saying that my client is now stuck with this stalking order on her for life, and it can never be challenged regardless of what new evidence comes up to show that the underlying allegation?
I'm saying based on the way that this was filed, yes, your client is stuck with this stalking order until you come up with legally sufficient grounds by which to challenge the stalking order. This should never have been accepted.
So, Your Honor, I mean, in the case I referenced, they even say such orders may be terminated when, on the respondent's motion, a court finds that the criteria for issuing the order under the statute are no longer present. And that's what we're here to argue, is that the criteria is not present, that there is no criteria for this STO because petitioner lied.
Yeah, you're basically relitigating. Those witnesses should have come forward back then.
We,
All you're saying is I have two people that are going to come in that said she lied. That's it.
yes,
That's what you have.
yes, Your Honor.
This is dismissed, counsel. And one of the attorneys for the petitioner should probably get a copy of this motion and a copy of this FTR and present it to the deputy district attorney, who would be able to move forward with charges for violation of this stalking order. My apologies to your client for the court's participation in this harassment.
Your Honor, are you specifically finding a possible violation of the stalking protective
I
order based
believe
on
this
legal
would be a
harassment
violation of the
ORC
stalking order.
or service of legal process not under ORC 7 and 9?
Yep.
Thank you, Your Honor.
Your Honor, this was done in good faith.
This was not done in good faith.
This
was not done in good faith.
But we honestly believe that this was done correctly. This was not done to harass the petitioner. This was
There's
done to find
no way, counsel, this was done in good faith. Have you read this affidavit?
Yes.
There is no way this was done in good faith. This affidavit says, on or about January 31st of 2021. Now, it had already been appealed. You had already received your ruling from Judge Jones. Respondent received a social media message from an acquaintance of petitioner who informed respondent that petitioner had confessed to fabricating a lie regarding respondent brandishing a gun in order to obtain the SPO in this matter. There is no way this is done in good faith. This is the slightest of slightest statements that can be listed in an affidavit. This is ridiculous. And this, I feel like the court, your client, is using the court to participate in her continued stalking and harassment of the petitioner. I apologize to your client that the court even accepted this. And I plan to talk to the members of the employees who work downstairs so that this type of thing doesn't slip through the cracks again, and that we don't subject future petitioners who have valid stalking orders to continued harassment in court. There's no way this is made in good faith. No reasonable trier of fact can read this affidavit and believe that this was filed in good faith. Just no way. So I saw that there was a request for attorney fees. Please submit it. I'll sign it upon receipt.
Yes, Your Honor. Your Honor, would you like that attorney fees request to continue to list the factors required in 20.075?
I would, thank you. And we have these general forms that I don't think appropriately apply to this situation because they're used in a situation where you have the initial stalking petition and then you have the contested hearing. I could sign it, it'll just be an order of continuance, but it would probably be more appropriate to have you, Mr. Green, or one of the other attorneys for petitioner draft an order.
Order of dismissal, Your Honor?
Order of dismissal.
Yes, Your Honor. Is that with prejudice or without?
Absolutely with prejudice. Did one of the other attorneys, I'm sorry I didn't really even let you all participate, have anything to add or say?
No, Your Honor, just that appreciate your ruling in this matter.
Mr. Nelson?
Your Honor, Tom Nelson, I have nothing to add. Thank you.
Okay. Well, stay safe and be well, guys.
Thank you, Your Honor.
Thank you, Your Honor.
do we have the parties? And
Yeah, and then it went from there. There was another case that I didn't get audio from. It wasn't relevant. Um, and yeah, I mean, I go back. The order that the judge ended up signing, flat out says that there was no actual evidence submitted to show the petitioner no longer feared for the safety. You know, there was no image of the social media post, no explanation for why they sat on it for a year before bringing it forward. Because again, this was the claim was made in January of 2020, and or sorry, January 2021. And it sat until they filed this motion in the beginning of December 2021. Now, it is worth pointing out a few things. There has been an objection filed in the case that Eric Wolf filed on behalf of his client at the time. Basically objecting that the whole thing was canceled without a hearing, that they were unable to submit evidence or testimony to establish the case. It still disagrees with the statutes that the judge said were appropriate. As well as other things. Now, there is a respondent has been advised to arrange for new counsel to represent respondent. This would be Dixie Bailey, because of a potential for conflict of interest. Now, I wouldn't be able to confirm what that would be at this point, but considering this hearing has set Dixie up for potential contempt charges, which for the first time I think would be a misdemeanor charge, from what I understand. But if he advised her to go through with this and knew that it was that deficient, there could be civil liability on his part, and that could be enough to say that he can't represent her in this matter. So we don't know yet what's going to happen from here. There is definitely going to have to be back and forth between the lawyers for both parties. Probably another hearing to address things, but that's where we're sitting there. There was something that it reminded me about when I heard this. And it reminded me of Alan Swinney's case, particularly when he was trying to get bail reduction. At the time, he was being represented by the Oliveros Law Group, which was the...
Good morning, Your Honor. Would you like me to...
Sorry. Which was the same law group that was representing Dixie Bailey in the original case. Eric Wolf was the lead attorney on both cases, and Mr. Oliveros, who was the head of the law firm, was present at the trial that in the stalking case that I sat in at, as well as this bail reduction hearing. Now, I do find it interesting that since then, Eric Wolf appears to no longer be with Oliveros Law Group and is now Wolf Law LLC, independent lawyer. That can happen for any number of reasons. It may have something to do with a number of weak cases that I've personally commented on. The one that I'm talking about, though, with Alan Swinney is they were supposed to come into a case for bail reduction with proof of why bail in a particular case was excessive. It was, I believe, about $524,000 for a broad variety of felony charges. With the way Oregon bail is structured, he would have needed to come up with 10% of that, about $54,000. It was a very high burden for Mr. Swinney to be able to get, but there was no evidence provided by Mr. Wolf or the Oliveros Law Group about why he couldn't reasonably make that amount of bail. And it got bad enough that Mr. Oliveros actually spoke up in court and essentially apologized to Mr. Swinney for failing that much. And I went ahead, it's only a few minutes of audio, but I went ahead and pulled it here. Mr. Oliveros and Judge Silver in that case talking about this.
And Your Honor, may I be heard?
Sure.
This is Mr. Oliveros speaking now.
I think that the court always has the discretion to allow evidence in, and I would agree.
To allow what?
Allow further testimony. If I were to make an offer of proof, Mr. Swinney would testify that he's unemployed, and it was mentioned in the state's memorandum. He would also testify that he has no money in the bank and he has no ability to borrow money. And certainly I understand the concerns that Your Honor has, but he is here to reduce bail because he doesn't have any resources. And granted, the memorandum did not hit that point, but if we're allowed to make an offer of proof, I don't want to file a motion to reconsider. I understand the court's perspective, and I certainly respect that. And I can only say that that omission of that evidence is something that we're responsible for, and not Mr. Swinney. But that's what he would testify to, Your Honor. If he could be called, he would tell Your Honor he's unemployed. He would tell Your Honor he has no ability to borrow money. He would tell Your Honor that he has not given our law firm one penny. He is, for all intents and purposes, insolvent. It creates a substantial hardship for him to even raise $50,000. And I bring all of this out, Your Honor, because the attorneys are responsible for the presentation of this motion, and I get that. And I don't want to call it an oversight, but I know that when the motion was prepared, we were looking at everything but that really important element of the defendant's financial condition. But he would tell Your Honor that he has no money. I mean, he has not given our law firm one penny to defend him in this criminal action. And while I agree the conditions that you've set forth for Mr. Swinney are the kinds of things that I would have contemplated, he just simply can't. He has no ability to raise the $50,000. I would like to put him on the record for this purpose, but again, I think Your Honor is aware that even if there was a mistake made earlier by our argument, that Your Honor always has the discretion to have Mr. Swinney testify to his financial condition.
Did you want to respond, Mr. Vasquez? I saw you stand up.
Yes, Your Honor, there would be, as we've already stated, that time has passed. And additionally, the state would have very direct and specific counters to all of those arguments presented by Mr. Oliveros. And the fact that he would be borrowing money, he has borrowed money, he would be seeking funds from other places. So that's all the things that we would do during the hearing, but that time has passed. And so I would ask the court just to proceed as we are.
Okay. And Mr. Oliveros, I appreciate that. known you for a long time. You've appeared in front of me many times, and I respect your ability as an attorney.
I guess what I,
But no, Mr. Oliver, this is not an on and on discussion, okay? You're the ones who set this hearing for an hour, which, when I see this, we're just a few minutes away from the top of the hour. When I saw that, that is generally done because the attorneys feel that's how much time it's going to take them to present the evidence they need in support of the motion, no matter what kind of motion that is. And there has to be an end at some point. You're right, judges have discretion to do a number of things, but it's limited. And there does need to be an end to the presentation of evidence. I allowed you to call a witness in what appeared really more like a rebuttal argument, because there was no evidence presented. When I said it's your motion, you may go ahead, that's when I would have expected evidence to be presented. You didn't. The state argued after Mr. Wolf argued, and then I allowed you to call a witness to testify to what the witness did, to what she testified. So I've already exercised my discretion to allow you to sort of reopen the case to present evidence, even after the state had said that you had presented no evidence about finances. You chose not to present any evidence about finances. I'm not going to continue to allow you to reopen and reopen and reopen. That's not the function here. Mr. Oliveros, I appreciate the fact that you admitted you made a mistake, but we're not going to continue on with a hearing that, if I let each of you continue to go back and forth because of something the other one said or didn't say, we're going to be here till 4 o'clock, and I have other hearings scheduled beginning at 1 o'clock this afternoon. You all are the ones who set it for an hour. Where was Mr. Oliveros? Please. Where was I on the close street conditions?
And yeah, eventually it just goes back to talking about restrictions if Mr. Swinney had made bail, which, as we know, he had not. But that's a whole different story, which I do plan to be doing another video. There has been a little bit of progress in Alan Swinney's case, where his attorney is trying to file for the judge to vacate the decision. I don't know if there's a whole lot for me to go over with it right now. I'll take another closer look later, and I might be able to do a short video about it. But yeah, that is some of the stuff that I wanted to get a chance to share out. There is definitely a lot of stuff that I have coming up. I did a pretty long Twitter thread about it last night on other cases. Some of them have been postponed because of the Omicron spike. Yeah, it's been a while since I've done any Minecraft stuff either, too. I need to work out a better way to handle some of that stuff, but yeah, I'm just taking a quick peek here. Like I said on Twitter yesterday, the Joey Gibson and Cider Riot related cases, those were supposed to be beginning of February. Those have gotten pushed out. We don't have a new date yet. Chandler Pappas is supposed to have he was supposed to be having his trial in Marion County this week, but the DA there got a contact with COVID and they reset the trial for it. I've gotten some news on some other cases that I want to poke in more on. There's just a lot of stuff going on, and I'm really hoping with the new, camera and mic rig, especially. Thank you everyone who's helped me to sort out the little hiccups that we've had here. I'm hoping I can come into the new year with some better work on some of this stuff and try to get some good information out to you all. The next event that I definitely plan to have stuff going on with is in a week. The City of Gresham is hosting another of their public feedback sessions about public safety in the city that is being put on by Barry Dunn, which is a consultancy group. They just recently canceled it being an in-person session, and it's going to be another Zoom session. So I do anticipate doing another live stream of it like I did last time. And yeah, I definitely, if you have business in the Gresham area, whether you live there, work there, visit there, whatever, I certainly do encourage and appreciate people to join the Zoom meeting or post directly to their feedback page to help get your voice out there. But if you don't feel comfortable being in the Zoom chat, or you just want to watch and chat in our chat here, then definitely we have that available as an option. Amazon wishlist, I should probably peek at it. Some of the stuff that I had on it might not be accurate anymore. I'd say give me like an hour or so. I can check it after I'm off stream here. Yeah, with that, I mean, definitely appreciate everyone that's come out today. If you know people that you think would appreciate, having an insight on some of the stuff that's going on, definitely feel free to share this video, share our social media. Down in the link in the video description is our link tree. Also, if, sharing the information is a huge help. If you do want to help in other ways, definitely, in that link tree, we do have donation options available. That's a difficult thing for a lot of people. Costs are going up on everything. Work is still a nightmare for a bunch of people. I totally get it. But yeah, definitely, everybody take care of yourselves. Have a great rest of the day. Probably a great weekend, because I don't know I'm going to have anything out before next week. But, take care, and we will see you later.